The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
Be seated. Welcome, everyone, to the Court of Appeals this morning. We have three interesting cases, and we look forward to hearing from counsel. In United States versus Lundy, Mr. Babineau.
Yes, sir.
Pleased to hear from you, sir.
Good morning, judges. It's my distinct privilege to represent Mr. Lundy before the court. Very narrow issue, as you can tell from the brevity of the brief that I filed in support of the appeal. Two issues I present to the court. This was a case in which, as you know, Mr. Lundy pled guilty to 2 counts of conspiracy to distribution of cocaine and cocaine base, as well as a firearm charge related to his drug charge. Subsequent to pleading guilty, additional information was gathered regarding Mr. Spencer, Sean Spencer, who was a cooperating government witness in the case, who was intimately involved in the case from the standpoint of the police investigation and ultimately the prosecution. What would have been the prosecution of Mr. Lundy had the matter gone to trial. We learned through a telephone conversation, which was from the jail, participated in by my client, that Mr. Spencer had changed at least his story as to my client's involvement in the crime. Based upon that, and based upon additional information being learned subsequent to the guilty plea by Mr. Lundy and myself as to the lack of involvement of his wife in any criminal conduct, he asked me to file a motion to withdraw his guilty plea pursuant to the Federal Rules of Criminal Procedure 11D 2B. And in that filing, I set out to the court that Mr. Lundy was in a position to show a fair and just reason for requesting the withdrawal of his guilty plea. And then the court Judge Dumar conducted a couple-day hearing in which a number of witnesses were called by the government.
Pretty much had a trial, did you?
We did, and that's what Judge Dumar said was going to happen, because at one point in time there was a motion to withdraw the guilty plea, and then that motion was withdrawn in light of...
Which brings me to my question. Please don't take this the wrong way.
Yes, sir.
No, you won't. But you must be very uncomfortable standing here this morning. Maybe not. But did you consider whether you should withdraw, either for purposes of appeal or for purposes of that trial that Judge Dumar insisted on having?
No, sir. I had not considered. I had not considered that. I had a very meaningful, good relationship with my client. As the court knows, he raised his right hand. He took the witness stand after being apprised of all the pitfalls associated with that.
Well, if you're comfortable, I'm okay. Just strikes me as the kind of situation that most lawyers wouldn't want to be anywhere near. I mean, you march your client in, you go through a fairly thorough Rule 11.
Yes, sir.
The plea is accepted. 5-6 weeks go by, and then boom, there's a motion to withdraw and lots of claims and issues raised, and the judge won't permit you to withdraw the motion to withdraw, insist on a 2-day trial. It just seems like you got caught up in a vortex that you'd have been better off being pretty far away from.
Well, I believe, Judge, if you can stand tall and you can look yourself in the mirror and know that you're zealously representing your client's interest at every possible turn, that you stay in the case. Many lawyers cut and run because that sometimes is the easy thing to do. I try not to be stupid either. I understand.
That's a good rule.
I understand that. I don't need the 2x4 to smack me upside the head.
I appreciate that.
But in this particular case, and part of the reason, as you can see from the record of the testimony of my client, there was a lot of information he agreed was discussed, but that he was not forthcoming about, with me in terms of his total motives and his entering his plea of guilty. And of course, he entered his plea of guilty, as he testified to, primarily because of the threat of prosecution of his wife, Miss Wilson. And he had an 11-year-old and a 7-year-old. They've since had a few birthdays since.
He told the judge he entered the plea guilty because he was guilty.
I understand that. That's what he said in the Rule 11 before the magistrate judge, and he agreed.
He claimed he didn't have enough evidence to prosecute his wife. That undermined it. He didn't get to he didn't get to consideration or something.
Yes, sir.
Is your best issue whether there was probable cause to prosecute his wife? The government says there is, or was.
Well, the government
There were
does.
multiple ways they could have prosecuted her, right?
Well, but the only ways they argue they could have prosecuted her would have been as a result of the search warrant that was executed in July, because the March 20th event of 2012, which is spoken about significantly in the record and was the overt act, one of the overt acts, the major overt act upon which my client's guilty plea was based, and the statement of facts focused.
But she also pled guilty in state court, didn't she?
Under the first offender statute to simple possession. That's correct. She did, and that
We
charge.
found drugs when they executed the search warrant. Found drugs in the house, and she lived in the house.
They did find drugs in the
And
house.
guns.
That's correct, and both of them, neither of them were prohibited from owning firearms.
Well, even they could have brought a gun charge against her. They could have brought the drug charges against her.
Well, they did bring gun charge against her too, but that is
They could
what,
have charged her with felony gun charges.
and
She was, and they didn't prosecute her based on this plea deal.
well, they allowed the state. This was a case that initiated with the Norfolk
Well,
Police
they let her
Department.
plead to a misdemeanor over in the state court.
She actually stipulated to the facts in the felony and got under the Virginia
some-
statute. The first offender was continued for a year and then ultimately dismissed
So
because
there's no record. Is that what it is? Is it a misdemeanor or no record?
it would show, because you can't get the benefit of first offender but one time in your life. So it would show that she was charged with a felony and the felony was dismissed under the first offender
Not a
statute.
convicted felon.
She is not.
She's not a convicted felon. So she got out from under
That's correct.
things as a result of the guilty plea, and she could have been charged with much. They had probable cause to charge her with a lot of other things.
I would
Federal court.
Well, I would disagree with that on a couple of levels. That there were drugs clearly present in the house, and there were guns present in the house, but she was not tied in any way. And matter of fact, the evidence.
She lived in the house, and she was her wife.
But this was a drug conspiracy, Judge, involving Henderson and Perry
And they had
and Lundy.
They probably could have proven she was driving that car. That
If they could have proven it,
pretty good circumstantial evidence.
I wish they could, but no one's been able to offer any proof. It was one police officer who said he saw a female in the vehicle, who he said at first he said my client was driving, then he said no, he wasn't driving. Then they said it was $500 that was involved in a half an ounce, and then it was $1,200
Of course, the
an
question
ounce.
is not whether they could have convicted her. Question is whether they had probable cause to charge and prosecute her.
Well, I think the power of the federal government, you can charge just about anyone with anything if you want to. But I'd like to believe that the power of the prosecution is a little more ethical than threatening to prosecute someone that you have little or no chance of succeeding against just because you can. And I think the carrot for...
She was in constructive possession of the drugs that were in that house.
I think she admitted she was in actual possession of drugs in the house, that she was a
So-
she was a user, but she was not involved in a drug conspiracy.
But it's just a small step to an inference of an intent to distribute. If your husband's a distributor and you're a user and you live with them, and you're in possession of all of it, I don't think it's a very large step to get to. She also intended to distribute.
Well, but this is,
She needed to earn money to support her own use.
well, she worked, and the evidence obviously was that she worked as well as he worked, and in addition to that, my client pled guilty to a drug conspiracy involving himself and Henderson and Perry, and then there was this cooperating witness, Spencer. And the government's evidence, based upon the hearing that we conducted and the information that we learned after the guilty plea, would maybe could have resulted in a guilty finding by a jury, but there was significant evidence that I believe that would dispute whether or not he was guilty of anything. And of course, in the United States v. Moore, this court's opinion, the six-prong test, if you will. In this case, Mr. Lundy, I think, did credibly assert legal innocence. We presented alibi evidence at this mini trial to determine whether the motion to withdraw the guilty plea was going to be ruled upon favorably in favor of Mr. Lundy. We showed that Spencer was no longer a credible witness by virtue of the jailhouse phone conversation. We found that Lundy and Perry both testified under oath that Perry and Henderson testified under oath that Lundy was not part of their drug organization.
Are you relating any facts here that are inconsistent with what Judge Dumar found after the hearing?
Well,
he made a bunch of findings on credibility, and none of them were favorable to you. Well, that I could perceive.
No, they weren't obviously.
So what you're
what
you're relating to us is evidence that you presented that Judge Dumar rejected.
That's correct.
And we would review those for clear error only. So he made findings of fact contrary to what you say, and unless they're clearly erroneous, we have to follow his facts.
You know, I thought what you were challenging is the denial of the motion to withdraw and not the plea colloquy. Am I right?
That's correct.
And so you were the lawyer.
Yes, sir.
And you're here today, and certainly I believe that you gave him close assistance. So what was wrong with the plea colloquy? Did he tell the truth then, or was he telling the truth later?
Well, and of course that was the same analysis that Judge Dumar did. He said, at the plea colloquy, you answered the questions this way. Now you're telling me, the judge, that you committed perjury when you did that. And he said, yes, I did.
And so the judge found that he committed perjury at this hearing.
That's correct. As a result,
found that the other
at some point in time, either at the hearing we were in or at the plea colloquy, one of the two.
He found that his testimony at this hearing was incredible.
He did.
That's right. So he didn't believe him at this hearing. So he found he perjured himself at the hearing, trial, or whatever you call it, the withdrawal hearing.
He believed.
And he found that the police officers and the government's witnesses were credible. Right?
He did.
He did.
And I would suggest the court, based upon the record, that was arbitrarily so. I don't think the court, obviously the court calls the balls and strikes, but I believe that that's not supported by the evidence in this case, and that he abused his discretion, and the defendant appellant, Mr. Lundy, should be allowed to withdraw his guilty plea. Thank you.
Thank you, sir. You have some rebuttal time. Mr. Hatch?
Good morning, Your Honors. May it please the Court, Ben Hatch on behalf of the United States. Your Honors, I didn't handle this matter below, although I did brief it to this Court. I'm Mr. Mitchell's supervisor. And I mention that because, to my perspective, the nature of the claim that's made in this case is that our office threatened to prosecute an innocent person, Mr. Lundy's wife, in order to induce another innocent person, Mr. Lundy, to plead guilty. And I consider such a claim to be very serious. And I'm happy to say that after what I think was an extensive amount of evidence presented on this matter, that Judge Dumar found that though the claim had been leveled, there just wasn't any credible factual basis for it. And I think that that finding is amply supported by the record. Mr. Lundy, I think what the record shows, Mr. Lundy was in a situation, there was ample evidence against him. There was also evidence against his wife. And
May I ask you, Mr. Hatch, does the record show what the surveilling agents observed the female do when the car pulled up in front of the Lundy home?
I think the record, the officer testified that there was the female driver,
Right.
the car pulled up, and that Mr. Lundy got out of the passenger side, and that there's not, other than
They
that she would have
essentially
driven
broke off.
away afterwards.
They broke off surveillance at that point, so.
Or that there was no particular activity on the female's part other than driving the vehicle, the drop off, and then driving away afterwards. I think he
The
testified.
female did drive away.
I can't say he said specifically that, but there wasn't any evidence that who was driving changed. And then the officer testified that they did follow surveillance after the car left, the white car left, and they followed it back to the Lundy residence, which obviously would be consistent.
Well, obviously, the reason for my question is, again, on this point about the prosecutability of claims against her. Obviously, if she'd gotten out of the car, if she parked and gotten out of the car and gone in the house, that would have bolstered would have seriously undermined any claim that you didn't have a prosecutable case against Mrs. Lundy.
Correct. And Your Honor, happily, I'm not in the position here of saying that there was probable cause simply based on an unidentified female, consistent with who was probably the defendant's wife, having dropped him off. Because, of course, as the court's already indicated, familiar with the record, there was a subsequent search warrant. And that search warrant disclosed drugs in common possession areas, guns, one of which she specifically identified belonged to her. And
That wasn't anything wrong with that, her having owned that gun. She didn't have any disabilities, did she?
No, Your Honor, not as felon in possession, although, of course, you can't own guns in connection with drug trafficking.
But the possession of the firearm, standing alone, it was not prosecutable against her on any facts in this record. With the drugs, maybe so, but go ahead.
Other than tying them with the drugs, no, Your Honor. And
Firearms standing alone was not. It wasn't an illegal firearm, and she didn't have a felony conviction on her record.
no, Your Honor, no.
I could find.
No, it would be the focus on the drugs and then the drugs in connection with that gun. And I think in this case, it's obviously the question is whether Mr. Mitchell had the basis to assert whether there's a reasonable basis or probable cause that she could be subject to prosecution at the time. And there were findings by Judge Dumar about that, but she actually pled guilty in state court under the first offender program, so ultimately that doesn't amount to a conviction. But here we have beyond a reasonable doubt, so it's not, I think, a close question as to her potential exposure.
Help me out on the timeline. I thought he pled guilty, and one of us said 6 weeks, but it was 6 months, wasn't it, before he was to be sentenced?
Yes, Mr. Lundy pled guilty in January, and then due to a continuance unrelated to this, he would have been sentenced in June. So it was about 5.5 months between his guilty plea.
And then the day before, he files this motion.
Correct. And I think Judge Dumar, there are 6 factors that this court's identified to assess in this context, and Judge Dumar, frankly, found every single one of them went against Mr. Lundy, and one of them, of course, was that 5.5 month delay. I do believe that's longer than this court's cases have suggested would be indicative of perhaps a fair and just motive. It was quite an extensive period of time, and Judge Dumar found that what had happened in the intervening time, and this was based on Mr. Lundy's answers to Judge Dumar's questions, was that A, Mr. Lundy's debriefing had not gone well. He had denied core conduct supporting his conviction. And so perhaps his hopes of the fruits of cooperation had dimmed. And then he also got the pre-sentence report, which had guideline ranges that apparently he thought were unacceptable to him. And so rather than innocence motivating him to move to withdraw it, he had landed himself in a position he didn't like being in and tried to move to withdraw it on that basis.
Why didn't Judge Dumar permit him to withdraw the motion to withdraw? Do you know?
Well, well, from reading the record, I'll say what Judge Dumar said, which I understand. Judge Dumar specifically had the defendant on the stand. After Mr. Babineau had indicated he would withdraw it, the defendant was called to the stand. And Judge Dumar was going through with him about, do you want to withdraw this? And he was, that is, to withdraw the motion. He said, yes, I do, yes, I do. But then Judge Dumar asked him, this statement of facts, which is obviously necessary to support it, do you agree with that? And he still said no. And then I think at that point, Judge Dumar basically made the assessment, I either deal with this now, and we're halfway through 2 days of hearings, or I deal with it over a year from now on a 2255.
I thought the request to withdraw the withdrawal motion was made just before the hearing commenced, the first day.
I'm sure Mr. Babineau will correct me if I'm wrong since he was there, but my reading of the record is that the first day occurred, then they come back sometime later for the second day, and at the beginning of that day, Judge Dumar had indicated some skepticism of the basis for the motion. Okay. And that obviously, and as it turned out here, if you're disputing core offense conduct, your acceptance of responsibility is at risk. I mean, my reading of this was that, in a sense, Judge Dumar might have been trying to telegraph to the defendant, this is a bad road to go down. You don't have a lot of basis. You're risking the benefits of your agreement that you reached. And so the defendant, in consultation with Mr. Babineau, said, okay, I will withdraw it, but then he was still denying the facts. So again, I can't truck with Judge Dumar's decision that, well, we're halfway through this, we might as well make our record now.
Sure, and technically you could prosecute him on the remaining counts now.
Correct. Correct.
He breached the plea agreement.
He did. He did.
But I don't mean to suggest that you would.
I think the United States is satisfied with the current disposition and hopes that that will remain in effect after this court's review. Unless there's any further questions. Thank you, Your Honors.
Thank you, Mr. Hatch.
Well, I have one other. Based on your argument, is it the government's position that we don't have to deal with the plea deal waiver?
Your Honors, if Your Honors want to decide this on the merits, I think at this point that's fine. We do have an outstanding motion to dismiss based on the plea deal waiver.
Let me ask you this. The thing that troubled me about that issue is that when Judge Dumar was discussing the matter with Mr. Lundy, he talked about the conviction, or he either talked about the conviction or the sentence, but not both. And so, therefore, my concern was not to entertain the government's motion or to deny it and just hear it on the merits.
Your Honor, candidly, the main benefit of that appellate waiver is so that we, from my perspective, we don't end up having to brief the case and then come do the argument, and we're already at that point in this case. So if the court, having considered the...
But Rule 11, we picked up on that as well, didn't deal with both of them, didn't deal with the sentence and the conviction both, in the Rule 11 quality.
I'm sorry.
So that wasn't covered in the Rule 11. Both facets were not covered.
Oh, that Judge Miller didn't specifically, although I think that the plea deal would have...
Maybe the plea agreement would cover them, but it wasn't covered during the plea colloquy.
I see.
In the Rule 11. That's the point that Judge Floyd's making with you.
I see. Well, the court...
It may not be well-founded, so you may be better off to let us deal with the merits of it.
That'd be fine, Your Honors. I think, I would take the position, obviously, I don't think that the judge in the plea colloquy has to go over every line in the plea agreement, and that their plea agreement obviously does cover the sentencing. But at this point, Your Honors, the court's heard argument, and if the court would prefer to affirm on the merits, that'd be fine with the United States. Thank you.
Thank you, Mr. Hatch. Mr. Babineau?
Just briefly, just to clarify the issue, unless the court has any additional issues for me, Judge Davis, the motion to withdraw, was after the evidence had already started, and then when it came after that, my client asked me to make the motion to withdraw, and then, of course, that's when Judge Dumar was dubious of all that was going on at that point in time, so he wanted to continue to conduct the trial, if you will, as if it was a trial. I don't have any additional argument if there's no additional questions for me.
Very good. Thank you, Mr. Babineau.
Thank you.
We'll come down and greet counsel and then call our next case.